This channel examines the Jeffrey Epstein case using court documents, public records, and verified reporting. We do not speculate. We do not accuse. We document what exists, and what remains unanswered. Everything presented here is drawn from publicly available sources. This is not a theory channel. This is the file. In 2008, Jeffrey Epstein avoided a federal trial that could have put him in prison for life. Instead, he received a plea deal. A deal that reduced serious federal exposure to state-level charges. A deal that shielded unnamed co-conspirators. A deal negotiated behind closed doors. For years, one question has echoed. Why? Why would federal prosecutors step back from a case involving multiple minors? Why negotiate when a draft indictment reportedly existed? Why accept a resolution that seemed dramatically lighter than similar cases? To understand the deal, we have to step back from outrage and look at structure. In 2006 and 2007, the federal government was reviewing evidence gathered by Palm Beach police. The FBI had interviewed victims. Investigators believed they were looking at a pattern, not isolated incidents. Under federal law, charges could have included sex trafficking of minors and conspiracy. These carry severe penalties. But prosecution is not automatic. Federal prosecutors weigh several factors before filing an indictment. Strength of witness testimony. Credibility challenges. Resource allocation. Risk of losing at trial. Legal complexity. Cases involving minors can be especially difficult in court. Defense teams often attack memory inconsistencies, timeline gaps, and credibility under cross-examination. Epstein's legal team was experienced and aggressive. At the same time, prosecutors faced another reality. Federal sex trafficking law in the mid-2000s was still evolving in how it was applied to complex cases involving grooming and recruitment without overt force. The legal theory may have been strong, but courtroom outcomes are never guaranteed. Still, legal risk alone does not fully explain the scale of the deal. Because what happened next went beyond ordinary plea bargaining. Instead of filing charges and negotiating after indictment, prosecutors negotiated first, and agreed not to file at all. That decision reshaped the entire case. To understand why the deal happened, we have to think like prosecutors in 2007, not like observers in hindsight. Federal prosecutors do not simply ask, "Is the defendant guilty?" They ask, "Can we prove this beyond a reasonable doubt to a jury?" That distinction changes everything. At the time, the potential federal case relied heavily on testimony from teenage victims. Many were minors when the abuse allegedly occurred. Some had inconsistencies in timelines. Some had received money. Defense attorneys would almost certainly argue consent confusion, financial motive, or memory gaps. Even in strong cases, cross-examination can destabilize juries. Epstein's defense team signaled they were prepared for an aggressive fight. They reportedly hired private investigators. They challenged witness credibility. They prepared to litigate pretrial motions that could narrow or exclude evidence. A federal sex trafficking trial would not have been simple. It would have been long, high-profile, and risky. Prosecutors also faced legal uncertainties. In the mid-2000s, federal sex trafficking statutes were still being tested in courtrooms nationwide. Some provisions required proof of coercion, force, or manipulation across state lines. The exact framing of recruitment and exploitation in cases involving grooming was still developing through case law. If prosecutors overreached and lost, the outcome could have been devastating, both legally and reputationally. There is also a practical reality. Federal prosecutors manage hundreds of cases simultaneously. Resource allocation matters. A complex, multi-victim trial involving a wealthy defendant could consume enormous time and manpower. Plea agreements often reflect risk management. From a purely strategic standpoint, prosecutors may have believed that securing a conviction, even at the state level, was safer than gambling on a federal trial. But here's where the calculus becomes harder to defend. Risk management explains negotiating. It does not fully explain immunity for unnamed co-conspirators. It does not explain why victims were not informed during negotiations. It does not explain why the agreement was structured as a non-prosecution agreement rather than a traditional plea after indictment. Those choices went beyond caution. They altered the architecture of accountability. So while legal uncertainty and trial risk may explain part of the decision, they do not tell the whole story. Legal strategy explains part of the deal. But influence explains the environment. By 2007, Jeffrey Epstein was not an unknown defendant. He was socially connected to wealthy financiers, academics, politicians, and public figures. He moved in elite circles. His residences were gathering places for powerful individuals. That kind of access does not automatically produce protection. But it changes dynamics. High-profile defendants bring complexity. Media exposure becomes a factor. Political optics matter. Institutional reputations are weighed. Prosecutors know that certain cases will draw national attention and scrutiny. Epstein's defense team reflected his status. He retained prominent attorneys with deep experience in federal litigation. These were not public defenders or local counsel. These were lawyers who understood negotiation leverage, procedural tools, and how to apply pressure strategically. Reports later revealed that Epstein's attorneys engaged in extensive correspondence with federal prosecutors. Letters were exchanged. Meetings were held. Arguments were presented not only about evidence, but about proportionality, fairness, and legal interpretation. In high-stakes cases, negotiation can become less about courtroom combat and more about controlled resolution. There is no documented evidence that a single phone call ordered prosecutors to stand down. But influence rarely operates that way. Influence is quieter. It's access. It's familiarity. It's the assumption that negotiation is preferable to confrontation. When a defendant can afford to deploy legal resources at scale, investigators, expert witnesses, procedural challenges, the government must weigh whether prolonged litigation is worth the cost. And cost is not just financial. It's reputational risk. It's the possibility of losing. It's the uncertainty of a jury. In many federal cases, plea agreements follow indictment. The government files charges first, then negotiates. Here, negotiation preceded indictment. That sequencing matters. It meant the most serious federal charges were never publicly tested, never formally filed, never challenged in open court. And the Non-Prosecution Agreement included language extending protection beyond Epstein himself, shielding potential co-conspirators from federal prosecution. That breadth suggests negotiation leverage was substantial. Whether that leverage came from legal strength, social power, or the perceived risks of trial remains debated. But one thing is clear. This was not an ordinary defendant. And it was not an ordinary deal. To understand the 2008 deal, you have to understand the institution that made it. The U.S. Attorney's Office for the Southern District of Florida was not operating in a vacuum. Federal prosecutors answer upward, to the Department of Justice in Washington, and outward, to courts, political leadership, and public accountability. At the time, the office was led by U.S. Attorney Alexander Acosta. Federal prosecutors operate within constraints. Limited resources. Political oversight. Internal performance metrics. Risk sensitivity in high-profile cases. A high-risk, high-profile trial carries consequences beyond a single conviction. If prosecutors bring sweeping charges and lose, it damages credibility. If they pursue a case perceived as overreach, it can create political fallout. And this case had the potential to become national. There is no confirmed public record showing direct political interference. No memo ordering a retreat. No documented command from Washington to stand down. But institutions do not require explicit orders to feel pressure. When a defendant is wealthy, internationally connected, and prepared to litigate aggressively, federal offices must consider exposure, not only legal but reputational. A failed prosecution could have meant a public acquittal, questions about prosecutorial judgment, scrutiny from Congress or oversight bodies. In that context, a negotiated outcome can appear safer. The Non-Prosecution Agreement effectively removed uncertainty. It secured a conviction at the state level. It avoided the unpredictability of trial. It prevented extended litigation. From a narrow institutional perspective, it reduced risk. But reducing institutional risk can increase public risk. The deal limited transparency. It shielded potential co-conspirators. It avoided a public airing of evidence. And critically, victims were not informed before the agreement was finalized, a decision later ruled to violate the Crime Victims' Rights Act. Institutional pressure rarely leaves fingerprints. It shows up as caution, as compromise, as procedural containment. The question is not whether pressure existed in the form of a direct command. The question is whether the environment made bold prosecution less attractive than quiet resolution. If the plea deal had only reduced Epstein's charges, it would have been controversial. But one provision transformed it into something far more extraordinary. The Non-Prosecution Agreement did not only protect Epstein. It extended federal immunity to potential co-conspirators. Unnamed individuals, referenced broadly, were shielded from federal prosecution as part of the deal. That clause changed the scale of the agreement. In most plea bargains, prosecutors negotiate with a defendant about the defendant's exposure. Sometimes cooperation agreements require defendants to testify against others. Here, the agreement insulated others from federal charges without public identification or courtroom scrutiny. Why would prosecutors agree to that? One possibility is strategic containment. If federal authorities believed proving conspiracy charges would be legally complex or dependent on vulnerable witness testimony, they may have chosen to narrow the battlefield. Another possibility is negotiation leverage. Epstein's defense team may have insisted on broad immunity as a non-negotiable condition of settlement. But broad immunity carries consequences. It limits future investigative flexibility. It closes doors before they are opened. It preempts prosecution without testing evidence. Years later, when the agreement became public, this clause became one of its most criticized elements. Observers asked, why protect unnamed individuals? What investigative paths were foreclosed? Was the government trading long-term accountability for short-term certainty? There is no publicly available evidence showing prosecutors believed widespread conspirators would otherwise be convicted and intentionally chose to protect them. But the structure of the agreement ensured that certain avenues would never be explored at the federal level. And that decision intensified suspicion. Because the immunity clause implied something larger than a single defendant. It suggested a system. Even if prosecutors' intention was risk management, the effect was insulation. The broader the immunity, the narrower the future. One of the most consequential aspects of the 2008 deal was not written in bold legal language. It was procedural. Federal law, specifically the Crime Victims' Rights Act (CVRA), requires that victims be informed of and confer with prosecutors during key stages of criminal proceedings, including plea negotiations. In Epstein's case, victims were not notified before the non-prosecution agreement was finalized. Negotiations occurred quietly. The agreement was signed. And only afterward were victims informed that the federal case would not proceed. This decision would later become central to renewed legal battles. Why would prosecutors exclude victims from the process? From a narrow institutional perspective, secrecy can preserve negotiation leverage. If a plea agreement is fragile, broad disclosure risks public backlash before terms are secured. Prosecutors may also have believed that because no federal indictment had been formally filed, the full procedural obligations of victim consultation were not triggered. That interpretation would later be challenged in court. In 2019, a federal judge ruled that the government had violated the Crime Victims' Rights Act by failing to notify victims during the plea process. The court acknowledged that the secrecy surrounding the deal deprived victims of their statutory rights. Although the ruling did not undo the agreement itself, it formally recognized a procedural failure. And that failure deepened public distrust. Because the issue was no longer only about sentencing leniency. It was about exclusion. Victims were not merely dissatisfied with the outcome, they were excluded from the process that determined it. This distinction matters. Justice systems rely on transparency not only to convict defendants, but to maintain legitimacy. When decisions are made behind closed doors in cases involving vulnerable victims, even legally permissible discretion can appear like concealment. The silence around the victims did not cause the deal. But it amplified its impact. It transformed a controversial plea agreement into a symbol of institutional opacity. For years, the 2008 agreement remained largely outside national awareness. Jeffrey Epstein served his state sentence. He registered as a sex offender. And the federal case quietly disappeared. There was no televised announcement explaining the non-prosecution agreement. No detailed press briefing outlining its scope. No public accounting of the immunity clause. To most of the country, the case looked like a local Florida prosecution that had ended. The deal stayed buried in legal filings and correspondence. Why? Because without public scrutiny, institutional decisions rarely resurface on their own. It wasn't until investigative journalists revisited the case nearly a decade later that the full structure of the agreement became widely known. Reporters uncovered internal communications, letters between Epstein's legal team and federal prosecutors, and documentation revealing how negotiations had unfolded. The immunity clause became public. The victim notification failure became public. The scope of the deal became public. And with exposure came backlash. Legal scholars questioned the breadth of prosecutorial discretion used in the case. Lawmakers demanded explanations. Survivors returned to court, arguing their rights had been violated. The story changed from a wealthy defendant received a lenient sentence to a federal case was negotiated away in secret. That shift was powerful. Because secrecy alters perception. Had the agreement been announced openly in 2007, debated publicly, and defended in real time, it might have been controversial, but transparent. Instead, it surfaced years later, detached from its original context, during a period of heightened public sensitivity to abuse and institutional accountability. The delay amplified outrage. And when Epstein was arrested again in 2019 on new federal charges, the 2008 deal became central to the national conversation. The question was no longer just why he was given a deal. It became, how is this allowed to happen? When the 2008 deal became public, many described it as unprecedented. But was it truly unique? Plea agreements are not rare in the federal system. In fact, the vast majority of federal criminal cases end in negotiated resolutions rather than trials. Prosecutors often weigh risk, resources, and certainty when deciding whether to push forward aggressively or settle. Non-prosecution agreements (NPAs) are also not unheard of. They are frequently used in corporate crime cases, financial misconduct, regulatory violations, compliance failures. But applying an NPA in a case involving alleged sexual exploitation of minors was highly unusual. That distinction matters. Corporate NPAs are often designed to secure fines, compliance reforms, or cooperation. They are negotiated in environments where monetary penalties are central. Epstein's case involved alleged exploitation of vulnerable individuals, not balance sheets. Critics argue the structure of the deal resembled high-level financial crime negotiations more than a traditional sex crimes prosecution. That raises a deeper question. Did Epstein's wealth and legal resources shift the frame of the case? When defendants can afford elite legal teams, prolonged litigation becomes a weapon. Every motion, every procedural challenge, every evidentiary fight increases the cost of prosecution. In such scenarios, prosecutors may choose containment over confrontation. This does not require corruption. It requires asymmetry. Powerful defendants can stretch timelines. They can threaten appeals. They can raise constitutional challenges. They can mobilize experts and investigators. In response, institutions sometimes prioritize certainty. But certainty can come at a cost. When plea agreements resemble negotiated settlements between equals rather than prosecutions of wrongdoing, public trust erodes. Was the 2008 deal legally permissible? Yes. Was it typical for the type of allegations involved? Not by most standards. That tension is what fuels continued scrutiny. The Epstein agreement may not have been illegal, but it was exceptional in structure and scope. Prosecutors are trained to win. Not symbolically. Not morally. Legally. Every federal prosecutor understands one core principle. Never bring a case you are not confident you can prove beyond a reasonable doubt. That standard shapes decisions long before a courtroom is involved. By 2007, Epstein's case carried multiple layers of risk. Heavy reliance on teenage witness testimony. Anticipated aggressive cross-examination. Legal gray areas in evolving trafficking statutes. A wealthy defendant prepared for prolonged litigation. Now add another variable: visibility. If prosecutors indicted Epstein and lost a trial, the consequences would be severe. A public acquittal in a case involving minors would not just free the defendant, it would weaken future prosecutions under similar statutes. Losing would not merely close one case. It could set precedent. Institutional fear is rarely dramatic. It doesn't announce itself. It operates quietly in internal discussions. What if jurors hesitate? What if witnesses break under cross-examination? What if appellate courts overturn key counts? The safer path becomes tempting. Secure a conviction. Avoid uncertainty. Close the file. From a risk management perspective, the Non-Prosecution Agreement achieved certainty. Epstein pleaded guilty in state court. He registered as a sex offender. The federal government avoided trial. But fear-based decision-making can distort proportionality. When avoiding loss becomes the priority, the scope of accountability can shrink. The question is not whether prosecutors acted illegally. The question is whether they acted defensively. Did they prioritize institutional safety over maximum exposure? Did they treat the case as too risky to fully pursue? Did fear of losing outweigh the possibility of winning big? There is no public memo that answers these questions definitively. But the structure of the deal suggests caution dominated. And in cases involving powerful defendants, caution can function as protection. Looking at the 2008 plea deal in its entirety, one pattern emerges. It was not the result of a single decision, but a convergence of factors. Legal complexity played a role. The evolving nature of federal sex trafficking statutes created uncertainty. Witness credibility, cross-examination risks, and procedural hurdles made trial outcomes unpredictable. Institutional dynamics played a role. The U.S. Attorney's Office weighed resources, reputational risk, and public scrutiny. Prosecutorial discretion allowed for negotiation rather than confrontation. Influence played a role. Epstein's wealth, social connections, and high-powered legal team created an environment in which negotiation was not just possible, but likely. Procedural choices amplified the effect. Victims were not informed. Unnamed co-conspirators were granted immunity. Federal charges were avoided entirely. Together, these factors produced an outcome that satisfied technical legality but fell short of moral clarity. The 2008 deal demonstrates how discretion, power, and institutional caution can intersect, sometimes to protect the guilty and shield the system from risk. It reminds us of a broader truth. Justice is not just about laws. It's about how laws are applied. It's about the environment in which decisions are made. It's about who has access, influence, and leverage. In Epstein's case, the convergence of law, power, and discretion produced a deal that still sparks outrage, debate, and reflection. The 2008 plea deal was more than a negotiation. It was a reflection of a system balancing risk, influence, and authority, and one that allowed a wealthy, connected defendant to evade the full consequences of his alleged actions. Understanding that convergence is critical. Because if we want accountability, we must understand how cases can vanish, not through crime, but through the choices of those tasked with enforcing justice. The documents exist. The questions remain. This channel will continue examining what is public, and what is still hidden. If you value documented analysis over speculation, consider subscribing. More files coming.